Fine. Dr. Fine is a professor of Jewish law in the Geiger College in Berlin. He served as a rabbi in New Jersey, and is president of the New Jersey Rabbinical Assembly. He earned his PhD in history at the City University of New York, and his rabbinic ordination of the Jewish Theological Seminary, also in New York.
The universal value of human life is considered axiomatic in Jewish criminal law, while capital punishment is clearly mandated in the Torah's legal codes. The Mishnah and subsequent rabbinic law established evidentiary standards, procedures of deliberation, and execution regulations that ensure that capital punishment could hardly ever be enforced. The tension between the Torah and rabbinic legislation is often cited to argue that the rabbinic view of the universal value of human life supersedes the Torah's intent. However, a somewhat different perspective is that the rabbinic position on capital punishment is in contrast to Roman, not Torah-itic law. Because the rabbinic courts did not adjudicate criminal matters, rabbinic criminal law was chiefly a matter of theory, and as such could afford to offer an enlightened polemic against Roman legal procedures. The aversion of the rabbis to capital punishment is no mere inference from their codified procedures. The Mishnah states explicitly in Makot 110, Sanhedrin ha'horeget echad b'shavua, that's 7 years, Nikrat Chavlanit, Rabbi Elazar ben Azariah Omer echad b'shivim shana, Rabbi Tarfon and Rabbi Akiva Omrim, Ilu hayinu b'Sanhedrin, lo neharag ha'adam le'olam, Rabbi Shimon ben Gamliel Omer, Aten Rabim Shofet Amim b'Yisrael. Rarely does the mission of the rabbinic code of law engage in this kind of theoretical dialogue. The purpose of this text is to make perfectly explicit that capital punishment is not enforced. Of course, the theoretical possibility exists, but a court should rarely, if ever, employ it. Rabbi Tarfon and Rabbi Akiva's statement that had they been on the Sanhedrin, none would ever have been put to death, means that they would have made sure to find for the accused in any capital case. Their statement also implies that there was no Sanhedrin legally constituted to hear capital cases in the post-destruction era. The final clause, that they would even have multiplied murderers, seeks to clarify that they would have even knowingly exonerated murderers by allowing them to live. All of this is phrased in the subjunctive. They did not actually even have the option of doing so, because in their day there were no Jewish capital cases in Jewish law. That's why it says Eliyahu. A curious duality pervades all the rules, substantive and procedural, which deal with the death penalty, writes George Horowitz in his book, The Spirit of Jewish Law. On the one hand, the Torah declares certain offenses punishable by death. On the other hand, the rabbis, in expounding and developing such commands, establish requirements which make conviction well nigh impossible. End quote. The principal procedure to which he refers is not only the requirement of 2 witnesses to the criminal act, but also the requirement of 2 witnesses that the accused was warned beforehand that the act was illegal and that intentional commission carried the death penalty, la hajra'ah. Other aspects of Jewish criminal law procedure are the requirement of the Court of 23 that the deliberations must begin with an argument for acquittal, that a vote of conviction must be by a majority of 2 or more, that no verdict of acquittal can be reversed to conviction, that the court can only hear arguments for acquittal brought before it, that members of the court can change their vote from conviction to acquittal, but not from acquittal to conviction, that the court must reconvene the following morning rather than deliberate into the night, but that a verdict of acquittal can be reached on the first day of the trial, but a verdict of conviction can only take place after an overnight recess to the following day, that the junior members of the court state their opinions before the senior members so as not to be influenced to convict. All of these rules apply to non-capital criminal cases as well, except for the 23-judge bench. This is all based on Mishnah Sanhedrin in Chapter 4. All of these procedures are weighted in favor of the accused. It is these procedures, the requirements of witnesses, of a warning, and the specific limitations that the rabbis put on the actual various capital offenses that make the practical application of execution highly unlikely. That is the nature of the procedure that Mishnah Makot 110 describes. The rabbis did not merely dislike capital punishment, they mapped out a procedural system where it could hardly ever be applied. Even when it could apply, there was ample latitude for the discerning judge, like Rabbi Tarfon and Rabbi Akiva, to make sure it would not. Along these lines, George Footmore summarized the law in his book, Judaism in the First Centuries, that it is clear that such a procedure conviction in capital cases was next to impossible. This was the intention of the framers of the rules, as equally plain. These rules of procedure impress us as purely academic. It cannot be imagined that any government charged with the maintenance of public order and security ever devised and put into practice a code of procedure, the effect and intent of which was to make the conviction of criminals impossible. Such rules could only have been conceived at a time when the administration of justice in such cases was in foreign hands. End quote. Now, while the rabbis may have been compelled by historical circumstances to distance themselves from the practical application of criminal law, they assumed the moral high ground in articulating a universal value of human life in an extraordinary Mishnah that begins by specifying the judge's instructions to the witnesses in capital cases. The rabbinic code in Sanhedrin 4 gives us the full text of a sermon on the value of life, which is often quoted without the context of criminal law. כיצד מבין על עדי נפשות, היו מכניסים אותם מן עליהם, שמה תאמרו, אמרו לשמועה, מפי אדם נאמן שמענו, או שמה שאין אתם יודעים שסוכנו לבדוק אתכם בדרישה וחקירה, היו יודעים שלא כדיני ממונות, דיני נפשות. דיני ממונות, אדם נותן ממונו מתכפר לו, ודיני נפשות, דמו ודם זרעותיו תלויים בו עד סוף העולם. שכן מצינו בקין, שנאמר כל דמי אחיך צועקים אליי מן האדמה. אינו אומר כל דם אחיך, אלא דמי אחיך, דמו ודם זרעותיו. לפיכך נברא אדם יחידי בעולם, ללמד שכל המאבד נפש אחד מישראל מעלים עליו כאילו עובד עולם מלא. וכל המקיים נפש אחד מישראל מעלים עליו כאילו קיים עולם מלא. The Mishnah continues to give alternative explanations for why a single human being was created, but the point here is that the judges give the witnesses a sermon about the importance of human life after warning them about the danger of wrongfully accusing someone in a capital case. The word Israel, causing a single soul of Israel to perish or saving a single soul of Israel, is missing in some manuscripts. Without the qualifier from Israel, the sentiment is clearly universal. And because the argument applies to all human beings as all derived from Adam and Eve, it seems that the more universal meaning fits better with the context. Either way, the sermon makes clear the importance of each life and its potential. This mindset underlies the rabbi's aversion to capital punishment, and the genre of the sermon clearly implies that this is a polemic. The theoretical rather than pragmatic element of rabbinic criminal law can be inferred, not just from the nature of the rabbinic law itself, but from what we know of the role of the rabbis in the late Roman Empire. The rabbis played an informal, popular-based role in Roman Jewish society. They had no official authority. They did not represent the people to the imperial government that the patriarch did. And while the patriarchate was closely connected with the rabbinate, it's not the same thing. They did not run the synagogues that the wealthy Euergetus did, the philanthropist, as can be inferred from the epigraphical record of the synagogue mosaics and inscriptions where donors are mentioned as the archisynagogue, but rabbis are hardly ever mentioned, while the artistic imagery of synagogue zodiacs seems to violate rabbinic sentiments and pagan imagery. And neither did they run the judicial system, as that was a function of the Roman provincial government, as can be inferred from among other sources the Babata papyri, an archive of legal documents belonging to a wealthy Jewish woman of the early 2nd century who brought multiple suits on matters of family and civil law to the Roman courts. What the rabbis did offer was an alternative to the Roman courts. Babata may have been an exception, as the evidence of the rabbinic literature, especially the Yerushalmi, as analyzed by Catherine Hezer in her book Form, Function, and Historical Significance of the Rabbinic Story in Yerushalmi Nezikim, argues strongly that the Talmudic discussion of case law involves civil matters, that's monetary disputes, laid into practical case law and procedures, not the impracticality of criminal procedures. The rabbinic civil courts then function as what we would call private arbitration courts. Jewish litigants would agree by mutual consent to bring civil cases to the rabbis. We know as well that the Romans considered the rabbinic courts as legal arbitration courts and were willing to enforce their decisions. A Roman law from the year 398, instituted by the emperors Arcadius and Honorius, which is codified in the Theodosian Code 2110, required the Jews living under Roman authority to address all non-religious matters to the Roman courts, but then states, certainly, if some shall deem it necessary, to litigate before the Jews or the patriarchs through mutual agreement, compromisum, In the matter of arbitration, with the consent of both parties and in civil matters only, they shall not be prohibited by public law from accepting their verdict. The governors of the province shall even execute their sentences as if they were appointed arbiters through a judge's award. The law applied the same division of labor between Roman courts and Christian ecclesiastical courts, allowing the Christian courts to serve as courts of arbitration in matters of civil law, as well as, of course, ritual and theological infractions. But criminal law remained the domain of the state. The compromissum was the formal agreement to arbitration that the Romans wanted all private litigants and private courts to use. Whether the people did so or not is a rather large question, although the term compromissum does appear occasionally in rabbinic legal literature. It appears, for example, in the Yerushalmi in the Moed Katan. But the Hebrew term shetarei berurim, which probably refers to the Roman compromissum, appears with greater frequency in the Mishnah itself, in Moed Katan and Baba Metzia and Baba Basra. To support this, both Christian and Jewish statements exist exhorting people to keep their legal disputes internal. There are statements in the New Testament, 1 Corinthians and Luke, as well as in the rabbinic literature, in the Tosefta Sanhedrin, the Sifrei Devarim, the Yerushalmi Sanhedrin and Babli Sanhedrin. And historians of Roman law describe the existence of private arbitration courts as alternatives to the imperial court system. As Jill Harry's writes in her book Law and Empire in late antiquity and others. Finally, the Mishnah itself sets the procedure for civil cases where each litigant chooses one of the judges of the three-judge panel, while the third judge is mutually agreed to, as described in Mishnah Sanhedrin chapter 3, which is a reasonable procedure for a voluntary court of arbitration. The arbitration nature of the rabbinic courts indicate that the Jewish courts, as well as Christian ecclesiastical courts, were voluntary because there was no sovereign authority. For the same reason, the rabbinic courts did not hear capital cases, which they had no authority to do in the Roman system. The only example of a Jewish capital conviction is that of Jesus, albeit attested to only by the Christian scriptures, none of which were contemporary. The Gospels relate that when Jesus is arrested, he was brought to the Jewish priests who gather a council and find Jesus guilty. Thereupon he is handed over to Pontius Pilate for execution. The Gospels assume that while the Jewish authorities could so deliberate, only the Romans could inflict the sentence. In John 18:31, Pilate actually says to the Jews, "Take him yourselves and judge him according to your law." But the Jews replied, "We are not permitted to put anyone to death." This verse has engendered much debate among scholars over whether the Jewish courts exercised capital punishment in the late Second Temple period. But no one claims that they have the authority in the post-destruction rabbinic period when the codification of the capital procedures took place. And yet it is worth noting that the significance that the trial of Jesus is the only real case we have, besides perhaps the dubious claim of Rabbi Jonathan in Sanhedrin 71 that he saw a stubborn and rebellious son and sat on his grave. The trial of Jesus is cited in the Talmud, Sanhedrin 43a, but only in the manuscript, as the passage was censored for the printed edition. As elegantly discussed by Peter Schaefer in his book Jesus in the Talmud, the account, which appears only in the Babylonian Talmud from the Sasanian Empire where it was safe to speak against Christianity, it presents a Jewish counter-narrative rather than deny Jewish culpability, as much Christian-Jewish interfaith dialogue seeks to do in our day. The Talmud proudly accepts Jewish responsibility for execution. That being said, the latest of the sorts, its provenance in the Bibli and its polemical nature clearly devalue its use as a testimony for what may or may not have happened centuries before. The far likelier scenario is that the Gospels in their approach to absolving the Romans and seeing the Jews as the rejectors of Jesus as Messiah transfer responsibility from Pontius Pilate to the Jews. That is the best way to understand John 18:31, which shows not only that Pilate, according to John, wants to send the case back to the Jews, just as he tried many other times in the various accounts to avoid decreeing Jesus' crucifixion, but also explains why the Jews would need to point out to the Roman procurator that they do not have the authority to inflict capital punishment. If that were the case, Pilate would have surely known that. Whatever the historicity is of the trial of Jesus, there can be no doubt that it is the exception that proves the rule. The Jews, at least in the rabbinic period, did not execute. If the rabbis sought to teach that human life held value, they were offering a social and moral critique of the wider Roman world whose values were expressed in the Roman imperial legal system. Roman justice was harsh. As Jill Harry puts it, at no period in our history were the Romans known for leniency toward the condemned. Punishment, whether it be monetary, corporal, or capital, served three primary purposes in Roman jurisprudence: correction, reform of the wrongdoer, deterrence, and retribution. When understood in these terms, the differentiation between civil and criminal law becomes more formal than essential. In Jewish law as well, the difference between dinei mamanot and dinei nefashot is formal in different procedures and obviously different results. But a monetary penalty, a lashing or execution, would all serve to help correct the abuse. Well, in a capital case, it would be a final correction. To deter future abuse and to achieve retribution for the wrong party. In ancient law, criminal cases were still brought to court on behalf of the wrong party, not on behalf of the state. But these purposes of punishment stand in contrast to the religious purpose, both in Judaism and Christianity, where punishment achieves atonement. The spiritual possibilities of punishment in a religious context stand in stark contrast to the secular, we could say, Roman usage, where it was retribution that became more and more the determinant motivation. Since criminal charges were brought by the victims or their families rather than the state acted on their behalf in taking retribution on the offenders. Or revenge, as Jill Harries writes in her book Law and Crime in the Roman World, featured prominently in the language of punishment in late antiquity and was probably a motive earlier. What Ramsey McMullen calls judicial savagery in an article published in his book Changes in the Roman Empire, Essays on the Ordinary. Victims of crimes in the Roman world, whether Jewish or otherwise, went to the Roman courts to get revenge, because that was where they knew the offenders would face real punishment. The rabbi's attitude against capital punishment was surely a critique of Roman judicial cruelty, but it may also have been a critique of their own people who went to the Roman courts to inflict punishments on those who wronged them, that is, to seek revenge. It was those citizens, Jewish and otherwise, who maintained the Roman system, because law, as we know, was a reflection of the values of society.